Alex here with part 39 of the My Docket series on child custody and visitation. As with our previous videos, I'd like to take this opportunity to direct our viewers to part 0 if you haven't seen it yet. That is the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened. My ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one large example of my 8-year-long high conflict child custody ordeal from beginning to end in chronological order. We left off with the past 3 or 4 videos, actually I think it was 4 videos, having dealt with an issue surrounding medical benefit, insurance cards, and a few other ancillary issues. And moving on, we end up encountering, or at least I ended up encountering, a problem with vacations. And it was a problem on both sides of a coin. I had sent a message to my ex trying to exercise vacation time, and she gave me some kind of bogus response. I can't remember the details of it right now, but we're going to end up going through it once we actually look at the documents because it's attached as an exhibit. And I also had the sort of the opposite happen, where my ex used vacation time without providing notice. And again, she's not blatant about it. She says in a communication something along the lines of, since you didn't respond to me, I'm going to be taking him on this vacation. And I'm like, I never got a message from you. So just to, reiterate a little bit, I sent a message and she foiled that vacation attempt by me. And then she didn't send me a message and she just pulled a vacation out of her butt, basically, and claimed that she did send a message. I think this may have been the beginning of the email problem. It doesn't result in the use of our family wizard right away. That does eventually end up happening. But her games with the email communications, text messages, and stuff like that were annoying, and at some points they were manageable. Mainly, it's so hard to describe how she used communication. The best way to describe it is she would try to agree without appearing to do so if she ever had to. She would not really focus so much on clarifying things. In a way, it seemed like she would almost try to obfuscate things more with her communications. You're going to have to look at them for yourself to see what I'm talking about. And it's not something that you're just going to get in this briefing alone. It's going to be something that over and over again comes up. You're going to see more and more email attachments included in my paperwork. But that was another thing that she would do. She would also oftentimes try to bait me into an argument. So she would say things that now in hindsight, I'm pretty sure she knew were not true, just to get me to deny them so that she could then respond and argue with me. This is something that it took me a long time to figure out. In fact, I talk about it a whole lot more in the video communication. And off the top of my head, that's really all I can think of. She would also try to put words in my mouth. So a lot of times she would say, I would respond, and then she would respond to my response, saying something like, so what you're saying is, and I'd be like, no, I didn't say that. Why are you saying I'm saying what I didn't say? So this is just the beginning of a years-long, I guess you could call it, email confusion saga, because it was like a war of obfuscation and confusion and confounding, and it was just all, it was like you couldn't get a straight answer out of her. But it's so hard to really put a single label on what this conflict was beginning to represent, this specific conflict with the vacation. So I do want to mention that my mindset at this time was a mixture of positive and negative. I was really happy to have won the previous conflict, which was, again, the conflict on the benefits cards, by not having to go to court. For the first time, it became apparent to me that the judge could enter an order without me having to go in front of him. And when you're representing yourself against an attorney, that is very anxiety-inducing. It's terrifying. You lose sleep. Oftentimes, the day before the hearing, I couldn't sleep at all. I would wake up early, I would be strung out, and I was very pleasantly surprised to get a letter in the mail from the judge saying not only did I win, but I wouldn't even have to go into court and see the judge. And of course, as I mentioned in my previous videos, I ended up getting I ended up getting what I wanted anyway, because she turned over the medical benefits cards. She didn't end up fighting over that issue. The address issue, I didn't get what I wanted. In a sense, I did force her hand, and I forced her to have to go and get one of those fictitious address from the confidential address program. But that ended up being really the final nail in her coffin anyway. So, I mean, in hindsight, looking back, it was kind of good that that happened. It's awful to have to say that, but that one thing is a really glaring part of her mental health issue that really jumped out at everyone. And without that having been part of the case, I'm not sure that I would have been able to terminate her parental rights, because all of the other things that she did looked really bad, and I did end up getting a lot of relief, but the termination of parental rights was directly connected to her obsession with this victim complex, and that would not have become as obvious as it ultimately did had she not taken the route of getting the fictitious address. So I think at this point we can go ahead and take a look at what I have filed. Here we have the motion to set procedure for notice of vacations. If anyone has recalled the entry of the final order, they will know that there were some rules as to how many vacation days we could claim and how we could go about claiming those vacation days. In response to the communications breakdown with my ex, I am returning to court to ask the court to set a procedure on how we can go about claiming our vacation days. First paragraph, I identify myself. For some reason, I don't identify myself as appearing a proper person. So that's one thing that I want to point out. I should have done that. And I am indicating that I filed this motion. Let's take a look at the factual background. I am referencing the fact that we have joint physical custody, joint legal custody, the fact that our son was born to both of us, the fact that we were each to give each other 30 days notice to claim vacation days. The first allegation here has to do with during July having sent out a notice of vacation to my ex. When she did not reply, I sent her a second notice, at which point she claimed to have never gotten the first and accordingly refused to allow vacation time. So she's basically pulling the court order card. Now I want everyone to take notice of this, because in the future she does the exact opposite and expects to have a different treatment. She violates the court order on purpose a number of times, and she expects to just be allowed to go ahead and, exercise visitation time despite not following the order. So here she basically says that I have to follow the order. However, she, and you're going to find this out later on as we go further into the series, that she really doesn't have to. It's kind of optional for her. For her, it's a guideline. For me, it's a requirement. Next paragraph. Claiming, looks like during September she claims, oh wow. So it looks like I let that one slide. Because let me take a look here at the date. I'm filing this in September, yeah. So it looks like this infraction or court order violation occurred July. And I didn't do anything about it. I waited until September, where she claimed in an email that since I never responded to a notice of vacation that she sent me, that she was going to presume there were no issues, and here I am saying, hey, she's playing games because she never sent me anything. So this is what I talked about earlier in the video, with this really being a problem on both sides of the coin, both with me trying to exercise a visit and both with her, and also with her trying to exercise a visit. Argument. She's responded negatively ever since having lost physical custody, which is true. And if anyone hasn't seen my video, Fighting Makes It Worse, with a question mark on the end of it, they'll know that I actually talk about this. I refer to it as the cycle of revenge. When you're dealing with a high conflict ex and they lose, they don't become passive, they don't back down, and they typically get worse, and it's because they want revenge. And it can lead to a cycle of them losing more of their rights, then taking more revenge, then losing more of their rights, and then taking more revenge, over and over again until they have virtually no rights left at all, which is what happened in my case. So She has been adverse to any cooperation whatsoever. She responds to any form of communication with contempt, assumption, presumption, and accusation. I remember this very vividly, and I wonder to what extent I attached exhibits. We're going to take a look at those in a sec, because I know I attached some. The court has already handled this matter by clarifying the implied cooperation that is required between joint physical and legal custodians. Well, actually, I don't mention legal, but I should. Anyway, with regards to medical, vision, dental, and personal information, and here I am citing the court's recent order entered against my ex. In the next sentence, I indicate that it's in our child's best interest to spend quality time, including vacation time, with both of us. A loose structure, which has been taken advantage of, will only undermine the quality of vacations, which is true. And she's already frustrated one vacation, and anyway, let's continue on. Conclusion, the petitioner or me requests that the court order both of us, so it's a reciprocal order, to notify each other within 30 days of vacation, specifically by filing a notice with the court in the case. I don't think the judge goes along with this, but he does do something that I think solves this problem, because I don't recall this problem continuing long after, or even at all, after the court's entry of order. I have a video, by the way, called, I think it's called Vacations and Holidays, but I think I have another one called Timeshare Exchanges. The more relevant one is the one on vacations and holidays, because I warn people to try and structure their vacations in a way that those vacations begin after their ordinary visitation time, to give them sort of a buffer to take emergency action if they need to. So for example, if you claim that you want to take vacation starting during your ex's time and they pull a stunt, you won't be able to get in court anywhere near in time. Typically your vacation's ruined by the time you get a chance. But if you claim your vacation time at the tail end of your timeshare, it gives you a bigger opportunity to know if a shenanigan is going to be pulled, because if your ex is going to pull some kind of shenanigan, it wouldn't be something that would occur right when your vacation came up. It would be at the beginning end of your timeshare schedule, your ordinary timeshare. So if they just refuse to drop the child off to you at your ordinary, scheduled timeshare time, you will know several days in advance, hopefully, that something is wrong and you need to take action to save this vacation, emergency action. So I'm asking the court to order, us to file these requests directly on the docket, which I know for sure isn't ordered, but he does do something that solves the problem. I can't remember what it is, but we're going to eventually find out when we get through the next two parts of this series, when we get through the opposition and through the reply. Unless this is something that we stipulated to. I can't actually remember now, so even I don't fully remember how this ended up being resolved. I just know that it was resolved. Next page is the affidavit, which is in support of this motion. This affidavit is me swearing under penalty of perjury that all of the factual allegations that I have made are true. Affirmation, which just lets the clerk of the court know that there are no social security numbers in this document. Motion opposition notice, which is looks like the tail end of the motion. I'm indicating that a final order was entered, however, that this motion or opposition does not ask to change the final order, and that therefore I don't need to pay the filing fee. Another affirmation, this is the boilerplate, or you could call it the form version of it that comes from the Self-Help Center. Unnecessary, superfluous document, but at the time I continued to do this. I continued to attach these. Next we have the list of exhibits. I haven't talked about this in a while. I have talked about it before, but not in a while. And what I did mention is that in Nevada, the list of exhibits is required. If you do not include this document, the clerk of the court will reject the filing. And it just lets the court know all of the exhibits that are about to follow this specific document. So it looks like it's just one email. Exhibit 1, again, this is a separation page or a separator. This is also required. If you don't include separation pages like this, then again the document will be rejected by the clerk. Here's an email from her. If it's a really long one, I'm just going to glaze over it, and of course I'll take questions down in the comments below. She is indicating, it's from her to me, court order. She says that her lawyer is working on something, that I need to go through her instead of harassing her, which I don't know how I'm harassing her if I'm trying to exercise a vacation schedule. By the way, I don't know if I've mentioned this before, but the courts expect you to go through your ex's attorney on legal issues. So it would be inappropriate to say something like, hey, let's stipulate on this issue to modify child support. Like, that's a legal issue. But it would absolutely not be appropriate to do ordinary day-to-day parenting stuff with your ex's attorney. That's not co-parenting. So, like, hey, let's go to this doctor's appointment, or let's do this exchange 30 minutes sooner or 30 minutes later. That kind of stuff shouldn't be going through an attorney. That's parent-to-parent stuff. You're trying to, co-parent your child. So here I am trying to say, hey, can I take this vacation? And she's saying, hey, you need to go through the attorney. This is something that she did a little bit. It eventually backfires on her in court, and she stops. The dentist is the same one. I don't know why we're talking about dentist. I don't see anywhere in the court order where the judge wants me to dig up info on past appointments. She has a cough, so does he. Since I never responded to the last email, I apparently don't want to see him on his birthday. So I guess this is what I was talking about with her claiming the birthday as a vacation day. Let's see here. If you think I'm going to give you my address so you can show up in your... Again, if anyone is wondering about this specific topic, I'm avoiding this in these videos because this will trigger a yellow flag on the video. What you can do to get all of the info on this specific topic is watch part 30 of the My Docket series. The judge addresses it right there in that video. And if you're curious about the final order, watch part 32 of that video. This word, harass, she uses it repeatedly over and over again. I honestly think, in hindsight, looking back to 2009, I think she thought that if she put in writing that I was doing this, then the court would assume that I was. It's kind of like she thought that if she said it and if she wrote it down enough times, that everything that I was doing would count as harassment. But that's not at all how it worked. And in fact, when we get to the point where I modify physical custody, this ends up blowing up in her face too. The judge specifically addresses the abuse of the word harassment. She basically just attaches the label to whatever she wants. If you, continuing on with that. Actually, okay, so this last paragraph, take note of this, because this is what happens if you don't file motions. If you continue to try to pressure your ex, and I'm assuming that's probably what I did in the sense of I need to exercise this visit, or I need the benefits cards, or vacation, whatever. If you continue to do that when your ex doesn't agree, they're going to try to paint you out as somebody who's harassing them. This doesn't actually work in my case anyway. As I mentioned, it blows up in her face when we get to modify physical custody, but it's an unnecessary risk that I'm taking. Not all judges might understand this. My judge did, but other people might have judges who don't get this. So the best thing that you can do is watch the video failing to agree and follow the steps in that video rather than continue to send text messages or emails. I'm not necessarily conceding that that's what I did, but given the fact that it's 2009, I probably did, because at that point in time, I hadn't really figured out that my ex knew what she was doing. I kind of at this point thought that she didn't know what was going on, and I need to help her understand, that she's doing things that she wouldn't want done to her. Sort of treat people the way you want to be treated, or put yourself in somebody else's shoes. I didn't get that she didn't have the ability to really connect with that principle at this time, and so I would just continue to try to get it through to her. Well, one of the things I try to tell people is when you watch the video failing to agree, is that there are a whole lot of people out there that do know what they're doing to you, and they like doing it. In fact, I talk about the sadistic part of that piece of the puzzle in another video titled Hide Emotions from Abusers. So these are just two really good videos to watch, and this last paragraph here can be the consequence of not using the principles in the video filing or failing to agree, which is typically ask once, and if it doesn't work, file a motion or let it go. Looks like here is my request to her, and I'm asking for 10-day deadline, doctor's names and addresses, dates of past appointments that I missed. It's interesting here, I'm asking for some information on the appointments that I missed because she didn't tell me about them. And she's still using the same thing that she was last time, which is the court doesn't order it, so I don't have to do it. I talk about this problem in the video Many Fine Lines, where a high conflict ex will not do things through the lens or the parental compass of what's best for the kid. They'll do things through the lens of, I'm not violating the court's order. And one of the things I talk about in the video Many Fine Lines is they, by obsessing over getting away with everything that they possibly can that's not in the court order, they inadvertently violate the best interest factors. And by violating the best interest factors, they inadvertently cause themselves to lose custody, both physical and legal, and that's actually what happened in my case. On numerous occasions, she defended her actions, her misconduct, by saying that the court's order did not require her to do what was being asked of her. And the court would say, well, the court's order is one thing, that's contempt of court. I'm talking about best interest factors, what's best for your kid, which will impact custody. And she didn't seem to connect those two dots together, and she ended up losing both physical and legal custody because of it. address, which of course hasn't occurred yet, so I'm assuming that the fictitious address hasn't been issued yet, or I would have gotten that. And this is the end of this particular document. Next, we have the affidavit of service. And I'm indicating here that I served this document personally on my ex's attorney by physically taking the documents to the law office and handing them over to the lady that works behind the counter. And then another affirmation. Going into the aftermath, I filed a motion and affidavit, but they were both free filings, so I incurred $0 in costs. My ex's attorney filed nothing, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney would have probably charged a half hour to review that motion, but not just to review it. I'm lumping in some time there to call my ex and sort of ask her what she expected to be done, like whether or not she would agree to it or whether she wanted to file an opposition. It wasn't a very long motion, so I think 30 minutes is reasonable. Well, let's say 40 minutes, because there was probably some back and forth. And then, of course, reviewing it to determine, to what extent I had sort of a leg to stand on, that kind of stuff. So 40 minutes, I think, is reasonable. And the affidavit of service, let's just say 5 minutes. It's a standard 2-page document that just says she was served. So looking at 45 minutes here, which is going to come to a half hour, would be 125. So it should be 187.50. If the math isn't right, it'll come up correct on the panels that slide in right next to my head right here. And if anyone has any questions, go ahead, as with my previous videos, just post something down in the comments below, and I will see you guys next time.